It is my pleasure to introduce panel number 2, Text, History, and Tradition, What Historical Evidence Constitutes Tradition, and How Ought Originalist Judges Use It. I'm going to introduce our moderator, Judge Rag Singh Hall. Since 2019, Judge Singh Hall has served on the United States District Court for the Southern District of Florida. He is the first Asian American to serve as an Article III judge within the 11th Circuit. In 2011, he was appointed to the Circuit Court bench in Broward County by then-Governor Rick Scott. Prior to his service on the bench, he had stints as an assistant state attorney at a civil defense firm and at his own criminal defense firm for 18 years. He is a graduate of Rice University and Wake Forest University School of Law. Judge Singh Hall.
Thank you so much for that introduction. It's so nice to see everyone. We were just talking about how we have about 900 registrants for this year's conference, which is remarkable. And I think you're really going to enjoy this panel, not because I'm the moderator, but because we have, to my left, 4 individuals, all of whom clerked on the U.S. Supreme Court, and for 4 different justices. So really a pretty good range of perspectives here. Immediately to my left is Professor Sharif Girgis. He is an associate professor of law at Notre Dame. He joined Notre Dame in 2021. I'm proud to say I have a Notre Dame law clerk currently too, so that's good news. Prior to that, he practiced at Jones Day in Washington, D.C., focused on appellate and complex civil litigation. He clerked for Justice Samuel Alito on the U.S. Supreme Court, and before that for Judge Thomas Griffith at the U.S. Court of Appeals for the D.C. Circuit. As with any FedSoc conference, he's a Yale Law grad. So I think 2 of our 4 are Yale Law grads. So that's a good thing. He is really an extremely interesting individual, and his background focuses on the intersection of law and philosophy. In fact, in addition to all the other degrees he has, he's currently working on his PhD in law and philosophy at Princeton, which is where he got his undergraduate degree. Next to him is Jeffrey Harris, who's a partner at Consovoy, McCarthy, and Park. Jeff is really an exceptional lawyer. Just to get to the heart of who he clerked for Chief Justice John Roberts. Before that, for Judge David Santel, and the late Lawrence Silberman, who has written some really wonderful opinions as well. Jeff, unfortunately, went to Harvard, not Yale, but he's still here to join us. He's litigated numerous high-profile cases in the federal courts before, I think, 8 different circuit courts of appeal and the U.S. Supreme Court. So really a wealth of knowledge in terms of professional practice, and we're very lucky to have Jeff here. Next to Jeff is Professor Gary Lawson. Many of you know Gary from his days at Boston University as a law professor. He's now, thankfully for us, at University of Florida Law School. So I think he commented to us earlier that he's come to the right state, so he's happy to be here. Gary is one of the founders of the Federalist Society, and he has written numerous works. In fact, one of the things that I read that he wrote dealt with the ambiguity of the word originalism. So I think he's really an ideal person to be on this panel. He clerked for Justice Scalia twice. Once when it was Judge Scalia on the Court of Appeal, and then later when it was Justice Scalia on the U.S. Supreme Court. Very happy that he's here. He's also an expert in admin law, and I think you all know that this last term was really an admin law kind of term at the U.S. Supreme Court. Last but not least is my friend Judge David Strauss. Judge Strauss sits currently on the U.S. Court of Appeals for the 8th Circuit. He, at different points in his career, clerked for a number of different judges, but ultimately for the Honorable Clarence Thomas at the U.S. Supreme Court. He received his Bachelor of Arts degree with high distinction, as well as his Master's of Business Administration from University of Kansas. He also got his JD at University of Kansas, where it's not surprising he was editor-in-chief of Kansas Law Review. He has written many opinions dealing with the topic that we have today, and he's going to speak about some of those. Really, what spawned this panel is the Rahimi case. I do want to give you a little bit of background on Rahimi, and then what I'm going to do is I'm going to turn it over to the panelists. We're not going to do our normal 5 or 10 minutes each of a statement followed by rebuttals. I'm just going to have them talk about their thoughts on the use of history and tradition going forward. But where we are with Rahimi is this. Rahimi was an individual who was prosecuted in state court because he had committed an act of domestic violence. And during this act of domestic violence, he perceived that there was a witness, and so he took a gun and shot at the witness. He missed, but still, that caused basically the state to take his firearm away from him. Not right there. Right then, they basically leveled an injunction on him, but once the injunction was leveled on him, he, in 5 separate cases, threatened people with that firearm, and ultimately they executed a search warrant and took his guns from him. He brought a case, and he was arguing that under 922G, that's 18 U.S. Code 922G, subsection 8, he should not have lost the right to have his guns. He made a Second Amendment argument. That subsection of 922 specifically deals with domestic violence convictions. What you need to know is that in state court, he had due process, he appeared in court, he didn't contest the facts. But ultimately, what he did was he brought this case and he lost, but then Bruen came out. And Bruen came out in 2022, and so he returned to the court to try to get his guns back. And so really what the setup is we have Bruen in 2022. That came about as follows. You have Heller in, I think, 2008. You have McDonald in 2010. You have some other cases in maybe 2016. Bruen in 2022. And Bruen really, if you think about it and look at it, takes that Heller standard and just keeps it going. It's not a new standard so much as like what the media would let us think. But ultimately, what happens is he felt that because of the Bruen standard that he ought to get his guns back. And so Rahimi goes before the U.S. Supreme Court. And in 2024, our U.S. Supreme Court goes ahead and enters an 8-1 opinion. In terms of the methodology, I really think it's more of a 9-0, but we'll see what our panelists say. But it's 8-1 in terms of the result. Only 2 justices did not write, Justice Alito and Justice Kagan. So you have the majority from Chief Justice Roberts, a dissent from Justice Thomas, and everybody else wrote a concurrence. So with that, I think I'm going to go actually to Professor Lawson first. And the reason is I think you've written before, Professor Lawson, about the difference between what judges do and what words mean. And if you could kind of talk about that a little bit, that would be great.
Sure, I'll get us started with this. 35 years ago, one of our smartest people, Mike McConnell, said something that actually changed the course of my scholarly life. What he said was, interpretation is like architecture. Form follows function. And think about that, it makes a lot of sense. Why you are interpreting something has a lot to do with how you're going to do it and what you're going to look at. And you can be doing at least 3 things in connection with the Constitution that might lead you to start thinking, what does history have to do with this? You could be trying to ascertain the communicative meaning of a particular provision in the Constitution. Right? That's one. Second, and this is not necessarily the same thing. It can be the same thing, but it doesn't have to be the same thing. You can be a judge trying to decide a case employing the original meaning of the Constitution. And the third thing you might be doing is, as a judge or an advocate, trying to follow instructions handed down by the Supreme Court. And any one of those three tasks can call for some use of history, but they won't necessarily be the same uses, and they won't necessarily be the same history, right? So if you're following the instructions of the Supreme Court, you have to go track down whatever the Supreme Court says you have to track down, whether or not you think that's a good idea and whether or not it makes any sense. And if they tell you, go see what professional historians say about 1790 statutes on X, well, my gosh, that's what you need to do. The more interesting to we ivory tower academics who don't actually have clients and don't need to win cases is that first question. Suppose you're just trying to figure out what the Constitution means. Do you need to look at history? Well, sure, but history in that context is one of a lot of things that it would be helpful to be able to think about. Because what are you trying to do when you're ascertaining the meaning of the Constitution? You're trying to, if you will, get into the thoughts, not of concrete human beings, but of this hypothetical legal construct called we the people, because that's who the Constitution says wrote it. So figuring out those intentions it's not the sort of thing historians do. Historians can look into what real people thought. Historians can look into what actual events were and how the interaction between those people and events worked. The interpretation of the Constitution isn't looking for the same thing that historians are looking for. It's looking for a kind of fact, but for lack of a better word, call it a legal fact, because it's a fact that's actually constructed by lawyers, because we the people is a legal construct. And okay, if you're trying to figure that out, would history be helpful? Sure. So would psychology, linguistics, religious studies. You want to know what we the people's thinking? You better know something about religion, right? Philosophy, sure. Economics, maybe, right? Classical studies, because we the people's probably going to be fluent in Latin and classical Greek, right? So there's all sorts of things that it would be helpful to know a little bit about. Does history stand out in any kind of special role? And given the nature of the enterprise of figuring out the meaning of this hypothetical legal construct, who, by the way, the Constitution, I don't think, is actually written in English. I mean, it's written in a dialect of English, but it's not standard English. It's a dialect you might, for lack of a better term, call legal English, right? So historians are not necessarily going to be particularly well suited to figuring out what all of those things are. All right. So all of this is just to draw a distinction between what, number one, historians would be doing and what legal scholars would be doing. Where do judges fit into all of this? Well, as I said, if you're a lower court judge, you're going to be chasing down whatever the Supreme Court tells you to chase down, whether or not that has anything to do with the Constitution's original meaning. That's just your job. What about that rare case where you actually have an opportunity to get the right answer without the folks up there screwing everything up? What are you going to do there? Well, the big difference between what academics do and what judges do, well, there are two big differences. One is academics have a lot of time on their hands. They can take 3 years, well, assuming they have tenure, they can take 3 years to write the article, write the book. If you're junior, I don't know, did you have tenure yet, Sharif? I don't
Very triggering.
think so. That's then you might have a clock ticking. But judges, you got to decide this stuff in what, weeks, months if you're really, really lucky. It just changes the whole dynamic. So the kind of search that you can just as a matter of institutional role undertake as a judge is going to be qualitatively different than the kind of search you can undertake as an academic. So what do judges look for? They're looking for shortcuts. You're looking for rules of thumb. You're looking for, if you will, doctrine. So saying to judges, get the history right, I just think misunderstands what it is that judges are supposed to be doing, right? The other difference between academics and judges is the stakes for academics are very, very low, right? The stakes for what judges do is very, very high. So you've got these two things working against each other. Judges probably ought to be trying to get it right even more than academics should, but they're doing so under very, very serious constraints of time. And all of this is just by way of giving a diagnosis. It's why it is. If you're a professional historian and you're out there looking at what judges do and how they're using history, you're probably going to think it's a really lousy job. Well, it's like the historians are using the wrong criteria to evaluate what it is that judges do. You have to evaluate, are they trying to get the right answer? Are they trying to get as good an answer as they can get in the time and resource constraints they have? And what questions are they answering? They're probably not answering the same questions that professional historians would act. And one more thing, and then I'll shut up. Okay, suppose the professional historians come in and say, okay, judges, you've got this history all wrong, you're amateurs. And they file their amicus briefs, and they write their articles, and they write their books, and every once in a while those books are full of fraudulent stuff. Oh, we're one state south of that, aren't we? How do you tell whether the professional historians are full of it or not? I mean, this is an eternal problem for lawyers who are also, as I say, if they're looking for answers, trying to integrate the insights of psychologists and linguists and classical theorists and religious studies theorists and everyone else who has something useful to say about what an 18th century hypothetical legal construct might have thought. How are you going to evaluate their stuff without, being an expert in all of those fields? And that's not something that's confined to this. So I'll just end with this observation. In the Rahimi case, as I say, there were like half a dozen opinions. One of them was opinion by Justice Sotomayor. And what she did is emphasize how important it was to take domestic violence seriously, because Rahimi was under a domestic violence restraining order, and she has about a page and a half of citations to social science studies on the extent and harm of domestic violence. Now, nobody's going to question that she's probably right. There's a whole lot of domestic violence out there. Are those studies any good? Did she examine carefully all of those studies and look through their methodology and see? Of course not, right? How is that any different from what judges are doing with history? Judges have to decide cases, right? And expecting them to be detailed experts in all of these things just, I think, misunderstands the nature of the beast. So my answer to the question, what's the role of history, is, you use it when you can, you use it when you don't, but decide the case.
So one of the difficulties of having a panel that's this distinguished is we could have a FedSoc lunch individually with each of these panelists, and they could certainly keep our attention for the entire lunch individually. So I'm going to apologize in advance to Jeff and to Professor Gerges, because I'm going to go to Judge Strauss next. But Judge, hearing what Professor Lawson just said, how do you handle these issues in terms of through-year law clerks? Does it even start at the hiring stage? We know, for example, that Justice Gorsuch hired Stephanie Barclay, who was a professor at Notre Dame and now a professor at Georgetown, and in the interim was his law clerk. So that would be my first question. And then second, I know you've written in Jackson on the Second Amendment and Gallagher on standing. What kind of issues do you think the traditionalist approach will be used on other than just gun cases?
So those are both excellent questions. Unfortunately, I don't know of any professor that wants to clerk for me, so I have to try to find them, in their first year of law school in many cases. Hiring's been moved up, but I put an emphasis on people who are open to learn with a conservative or libertarian bent. And I have them if they're, for example, if they're at Notre Dame, I would want somebody to take classes with Sharif and with Nicole Garnett and, a lot of the conservative faculty who are there who are, sensitive to originalism and will teach some of that. You normally don't get it in law school. There are schools that don't have a single originalist on the faculty. And quite frankly, those are schools that I tend not to hire from. I mean, I just can't because the stakes are too high. I can't spend the entire year teaching somebody how to do the methodology that I need them to do, only to see them leave once they've figured it out. So it's something I really emphasize. And I also want them to be aware of sort of what's going on with with what I think to be a methodological battle going on at the Supreme Court right now. As you know, this panel is text, history, and tradition. But not all justices believe that all three things are important. If you ask me, if you ask Justice Barrett, it's text and history that have primacy, and she could perhaps do without the tradition. And she's been writing about that for a while. If you ask Justice Kavanaugh puts a huge emphasis on tradition. He has scaled it back a little bit in one of his recent opinions, but that's extremely important to him. And we can talk a little bit more about how an emphasis on tradition can lead to erroneous rulings. I think it's a very dangerous thing to go down the tradition route if you are a originalist. And so I think you got to spend some time thinking about your own judicial philosophy when you get on the bench, teaching your clerks what's important and what's not, and then trying to figure out what the right answer to a lot of this stuff is. But it's something that I certainly emphasize. Now, I have written a number of Second Amendment opinions, and the judge also talked about an opinion in the standing context. We are having that same methodological battle on the Eighth Circuit that the Supreme Court is having. I'm a text and history person, and I have been in the minority in a 922 G1 case, which is the felon in possession statute. I have written that that constitutionally the Second Amendment only reached, in terms of dispossession, dangerous people who have a history of danger or pose a danger, similar to what Justice Barrett concluded in the Cantor case. But some of the more traditionalists on my court view 60 years or 65 years since the felon in possession statute was enacted as enough of a tradition to perhaps constitute liquidation, to give a fixed meaning to the Constitution, which I don't agree with. And they have upheld or would uphold the felon in possession statute and wouldn't allow as applied challenges. So we're seeing that methodological battle that's going on at the Supreme Court playing out on a circuit by circuit basis. Many of these battles are being fought amongst people who purport to be originalists. They are certainly Republican-appointed judges. One of the things, though, I want to emphasize, while we fundamentally disagree on how the analysis should be conducted, the fact that we're having this conversation at all among judges when perhaps a generation ago that was not the conversation that judges were having is notable. I rather have the judiciary filled with people who want to, figure out the original meaning of the Constitution. We may disagree about how to get there, but that's a much easier conversation to have than to have living constitutionalists. We do have those as well, but having a judiciary filled with living constitutionalists where originalism simply doesn't matter. So I think it's a good conversation to be having. In the standing context, I just want to briefly, I don't want to take up too much time, but in the standing context, one of the things that I think you need to be aware of is this text and history, at the very least, is sort of infiltrating a lot of substantive areas of the law. And this is sort of a last half a decade development. And so standing, I used to be a federal courts professor. I'm a recovering academic. And I used to think standing's easy. Did somebody get an injury? Did the injury, is whatever injury traceable to the challenged action? And is it redressable? The 3 Lujan factors from Justice Scalia's opinion in that case. It's complicated now. Justice Kavanaugh in the TransUnion case added another layer, which is that it needs to look like a cause of action that people sued for in early law. And so standing doctrine is now starting to look a lot like Second Amendment doctrine. And there's certainly a lot of articles out there, and there's judges who have criticized whether the standing doctrine has veered off on the wrong path or not. But what I'm telling you is I think there's going to be more history, text history and tradition in all areas of the law, which is not going to make the press very happy because as you can tell, they've spent the last 2 years talking about how 3 years talking about how the Second Amendment has gotten off the rails. One more brief point. It's not that hard. The Second Amendment is not that hard. The history takes time. It takes care. It takes effort. You have to do a multidisciplinary approach. In my most recent decision on the drug user and possession statute, we had to get into medical historical literature, medical history literature, to try to figure out how the mentally ill were treated at the time of the founding with respect to their rights. It takes time. These opinions will not come out fast. And if you see opinions come out fast, and what I mean by fast is, a couple of weeks, somebody has not been doing their work. It takes months to put this together, and it's a really important part of getting the law right. So I have welcomed it. Other judges have not welcomed it, but I think it's good for the development of the law because I think we're moving to an originalist interpretation of the Constitution.
Thank you very much. It's interesting because you'd mentioned the press and them or the press writing as if this traditionalist approach is new. There's a really interesting article, if any of you are interested. It's from 1992, and it's Justice Ginsburg, then Judge Ginsburg. It's entitled "Speaking in Judicial Voice," and it's an NYU article. And in that article from 1992, she talks about use of tradition. I think that's also an interesting thing because there are a lot of commentators who say you can't do this historical tradition analysis unless you have the internet to help you. And of course, that was way before Al Gore invented the internet. So I think it's interesting. But Professor Gerges, let me turn to you on this then. Judge Strauss puts text and history first and tradition last. But aren't originalism and traditionalism the same thing?
Okay, so first I want to begin by thanking whoever's responsible for my being here. This is awesome. I was thinking as I'm taking in the numbers that I grew up in a state, Delaware, where a meeting of all of the state FedSoc chapters and a meeting of a single state FedSoc chapter would look exactly the same because there's one law school in the state. And this is an incredible showing of force. So this is great to be here. So I think originalism and traditionalism tend to be distinguished these days in something like the following way. Originalism is about your rulings being both compatible with and rooted in the original meaning or the original intent or the original understanding or the originally created norm of the provision in question. And traditionalism is understood as giving some independent weight to practices, which usually means things that the other branches have been doing, Congress and the president, for a long time or have failed to do for a long time, or things that state actors have been doing or not doing for a long time, and giving some role to that that's not just about figuring out original meaning. So in Rahimi, Justice Barrett says, I get it if you're using early practices as evidence of original meaning. The Congress that gave you the First Amendment, if it began its sessions with legislative prayer, then probably that legislative prayer is okay under the Establishment Clause because they wouldn't pass the amendment and then immediately turn around and violate it. And she said practices leading up to ratification can be relevant if the provision you're interpreting is adopting a pre-existing right, the way that the Second Amendment is understood to do. But if it's not either of those things, maybe it's okay if it's what Madison called liquidation, which I think of as like the political analog to judicial precedent. So a judicial precedent, we have an uncertain question. The legal interpretive question gets hashed out explicitly, and then we settle on an answer and stick to it to balance the benefits of getting the law right and having it settled. And the thought about liquidation is that the political branches can do that too. If the presidents and Congresses hash out the legality of the national bank and then arrive at an answer, and that gets embodied in practice over time, we defer to it as a kind of non-judicial precedent. But that requires the actors to have thought about the legal issue. When a court implicitly decides some issue but never actually adverts to it and the parties didn't hash it out, we don't treat that as precedent on that question. And so we shouldn't do that with political actions either. So traditionalism is something separate from originalism, or liquidation as a kind of adjunct to originalism would be reliance on practices not like that. What's an example? Well, in Dobbs, the court says we conclude that there's no constitutional right to abortion because states have long regulated abortion. So not that the states have been interpreting the due process clause, but just that they themselves have been regulating abortion. There's a long history of that, so there's no deeply rooted right to it. Or in Bruen, the flip side, that because that unless you can find a historical analog to a current regulation, the regulation itself is unlawful. Or in Noel Canning, one of the opinions, Justice Breyer's, puts a lot of emphasis on the fact that even long after ratification, the presidents had been making certain kinds of recess appointments, so those must be okay because they've been done for a long time. And I think Justice Barrett, in her opinion, in Rahimi says, I don't understand that last use of practices where it's not evidence of original meaning. And Justice Kavanaugh, I read to say something like, I get it, I don't have a neat theory for how to tuck it into an originalist framework, but there are some cases where original meaning runs out and precedent runs out, and then we're stuck with two options. We could do policy reasoning, or we could do history that's not an adjunct to originalism. We could do traditionalism. And if I'm forced to pick between those two things, I want to pick history because it feels more constraining, and my role as a judge is not to make policy. And I read Justice Barrett as responding effectively, a little bit there, a little bit in a free speech case from the same term called Vidal versus Elster, or from last term called Vidal versus Elster, that she says, well, there won't always be a historical analog. So even if you stick to the history in the way that you want to, that's just delaying the inevitable. Eventually, we'll come to a case where there's no historical analog for the regulation under review, and we will have to own the discretion and develop a judicially managed test to figure out if it's okay.
Great. So Jeff, I want you to offer your opinion on all that you've just heard, but also if you could even kind of take it to the Louisiana case that you argued on non-unanimous juries. I think that's a fascinating case, and certainly the private practitioners would love to hear about it.
Yes, can you hear me? Is this, yeah. So this is a good order because I guess I bring the practitioner perspective to the panel, and we see Justice Barrett and Justices Kavanaugh and Thomas and others having these theoretical debates about what is the role of tradition. And I view tradition as, we all know sort of original public meaning type arguments. These are, what was the drafting history? What are the Federalist Papers saying? What was the colonial practice that was either entrenched or disavowed? But tradition I sort of view as, in Bruen you see it as kind of what was happening in the 1800s sort of thing. And I'd love to talk about a case called Ramos. We litigated it, we didn't argue it, but just a fascinating issue that I think before the justices started actually talking about the methodology, it showed exactly what the pros and cons of this traditionalist approach were. So Ramos v. Louisiana, the question seems very simple. The Sixth Amendment guarantees a right to trial by jury. Very easy question. Is the jury required to be unanimous, or is 10-2 good enough? Only two states have ever allowed this, Louisiana since the 1900s and Oregon since the 1930s. In the 70s, you had this decision called Apodaca, which had one of the weirdest lineups you've ever seen. So it was 4 justices said the Sixth Amendment requires unanimity, 4 said it doesn't, and Justice Powell said regardless of whether unanimity is required, it's not incorporated. So in 2019, after decades of denying petitions on this bizarre split to reconsider it, the court takes it. And what I loved about the case is it gave us a chance. Apodaca was a very unoriginalist case, like a lot of opinions in the 70s. So we really got to dig into this kind of from first principles. And both sides used, again, what I would call like this 1800s evidence. It ultimately split 6-3. We had Gorsuch writing, joined by Thomas, Kavanaugh, Sotomayor, Ginsburg, and Breyer, and then Alito, Chief, and Kagan dissenting. Here are my takeaways on how the majority and dissent sort of anticipated these tradition arguments. Question number one, what's the level of generality? So the majority, Gorsuch says, going all the way up from the founding, Magna Carta through, Magna Carta, England, colonies, 1800s, until Louisiana in like 1895, there is a tradition of unanimity. So he says, looking at unanimity, here's the tradition. Alito says, wait a minute, not so fast. There are many ways in which various states have departed from the common law jury. So for example, 12, the great state of Florida, beginning in the 1870s, allowed juries with as few as 6 jurors. And I think today about 6 states go below 12. So when we're looking at this, is the tradition only unanimity, or can you say a tradition of states having flexibility to modify some pieces of a common law jury? Second one, huge issue, this comes up in Bruen. What's the role of outliers? So just like Bruen, where there were 2 states that did regulate open carry outside the home, which Justice Thomas called the outliers, we have these 2 states, Louisiana and Oregon. So do you draw, and they have had these laws for over 100 years, so do we draw the inference, well, there must be something questionable because they're the only 2 that do this, so we should be skeptical? Or is the tradition, we've now had 125 years of some states openly having non-unanimous juries? Second one, and I know Professor Gerges talks about this in his article, do we have to show that people thought the tradition was constitutionally required? This is a big one. So there's no question, we didn't dispute in the Louisiana case, unanimity was the norm or the practice or the tradition. But there was very, very, very scant evidence showing that the states or federal government thought this was constitutionally required, as opposed to just the way it's always been, subject to legislative modification. Then we get to, again, further anticipating these debates, what's the alternative to tradition? So we made an argument that looks awfully similar to what Justice Barrett argues, which is we had a really good, I think, although I guess the court disagreed, original public meaning argument. We said based on founding era, colonial sources, text, drafting history, the core of the right to trial by jury is you have to interpose a group of impartial citizens between the state and the defendant. And this is exactly what Barrett later talks about in cases like Vidal, where she's saying, what is the core of the right? And when we're liquidating this or adjudicating it, we're looking to see if the state is impairing that or is hindering the function of that. And we said, whether it's 10-2, 11-1, or 12-0, we are protecting what the founders viewed as the core function of this right, because there are citizens, good and true, interposed between the state and the defendant. So again, that looks a lot like what Justice Barrett has later articulated as the approach she would favor in the absence of doing this traditionalism. And then the last thing I'll say about this, I think Ramos underscores the need for consistency both on methodology and within a doctrine if you're going to do this tradition. So Justice Gorsuch, in the majority opinion, he cites 1800s treatises, state law cases. There's these civ pro or criminal pro treatises from the late 1800s. And he says, aha, this shows the tradition. And then Alito came back and said, wait a minute, there's also this tradition of the states departing from the common law jury. And Gorsuch responded in a footnote and said, well, that doesn't matter because that doesn't go to the original public meaning. And so it seems like we have to either do this or not, but can't sort of do it halfway. And then substantively, directly relevant, I'm sure, to a lot of you in Florida, I think the doctrine on this jury issue, in no small part because of the tradition, is completely inconsistent. I think the pedigree of 12 is basically identical to unanimity. And again, I'm not unbiased, but I would have argued that states do have some flexibility within limits to modify those. But now we have this world where unanimity is etched in the Constitution, but 6 states, including Florida, have been given flexibility to ratchet down from 12. And so I think, again, if you look at this from a tradition perspective, we've got, some inconsistency in the doctrine. So, I'll leave it there. But again, I think this case just really shows, if you're going to be talking about tradition, these are sort of the arguments that play out. And it's not quite as simple as it looks, because a lot of these have inferences that can be pulling in different directions.
Professor Lawson, I'm going to go to you if you have comments on that.
Yeah, I mean, if I was a judge in the audience right now, I'd be grumbling, but wait, how is any of this telling me how to use history or tradition in what I do? Why am I here? Just a couple of observations on why you're probably still going to be grumbling over dinner. Observation 1. Originalism as a theorized concept is very, very new. It's been around roughly about as long as the Federalist Society, been around about 40 years. The practice has been around for a long time. But as a theorized concept, actually, that's the book that I was signing out there, actually was created in the second-term Reagan Justice Department. I mean, and if you doubt me, take out your cell phones, pull up Westlaw if you can, Hein Online if you've got it, it's got a better database, and search for the words originalist or originalism in the Law Review database before 1980. Literally zero. Okay, 40, but so what? Well, 5 years ago when my son went to law school, he asked me, what's the thing I should read about originalism? And I didn't have anything to tell him. There is no canonical source that describes what originalism is, much less the methodology of originalism. Steve Calabresi and I are hoping to write one in the next few years, but we haven't done it yet. It literally doesn't exist. So right now and the 40 years is important because we haven't had a lot of time to work this stuff out. It's like we got the big picture right, but the devil is in the details. And if there were, infinite law professors in the academy toiling away, maybe we'd make progress. There aren't very many of us, right? So you got to give us, we don't know either. You got to give us some time to work some of this stuff out. Second brief, I hope, observation. On the tradition point, I mean, it's possible to have a constitutional provision whose meaning is go forth and liquidate, right? Whose meaning is actually you figure this out as you go. And there are actually a very small number of provisions in the Constitution that say things like, as Congress deems, or as this entity shall think necessary, which are essentially, the meaning of those is, yeah, whatever you folks come up with in the future, that's fine. It's nothing that rules that out, just like there's nothing that rules out a constitutional provision that says, do whatever a majority of the Harvard Law School faculty thinks is a good idea at the time. It's just an empirical question, how many provisions in the Constitution actually do that? And the answer is not very many, right? So I wind up on the, if you will, anti-traditionalist side, not out of any deep theoretical commitment against it, but I just don't think there are very many provisions that actually say that that's what you're supposed to do. There could be. I just don't think they're there.
Judge Strauss, any advice for a district court judge or any of the state judges who want to be true to Bruen, but serve in a state where maybe a case that's in conflict hasn't been expressly overruled? So you've got the tension between the precedent from the 11th Circuit versus Bruen kind of going a different way. What should we do?
So it's a good question, and it's a tough question, having not been a district court judge before. But I would encourage district judges in the room to do what I do when I see that the Supreme Court precedent may be a little off kilter, which is there is nothing wrong, and you should apply precedent. You are bound to apply precedent as a district judge. You know, you have to apply the precedent of whatever circuit you're in. But there's nothing wrong at the end of your opinion or in footnotes or however you want to do it to explain why you think that the circuit precedent might be incorrect, that you're faithfully applying it, but maybe the circuit perhaps would want to rethink it. Doesn't mean they'll listen. Oftentimes that falls on deaf ears. I completely understand that. But at least you can start the conversation and hopefully get in the mind of some of the circuit judges. This might be an issue that you might want to take en banc or reconsider. I do want to make one quick point because a lot of folks have been talking about tradition, and I just want to kind of veer back to the area I know best and sort of go through a little bit of a thought experiment, which is this. So if you do tradition, to do it right and to obtain original meaning, you have to be extremely disciplined. And what I mean by that is taking the felon in possession statute, for example, or any of G, 922G, the mentally ill, drug users in possession of a firearm. If you say the tradition is the 65 years or 70 years since that statute was enacted, and it wasn't litigated for the first 45 years under the Second Amendment, then you're going to falsely think that wrong practice is the right meaning of the Constitution. So if you're weighing history and tradition equally and you're not disciplined like Justice Barrett is, where you're looking at history that is relevant to understanding the provision, then I think you get off course and you make some bad assumptions about what tradition is really trying to do, which is to tell you what the original meaning is. I do agree that if you're a district judge, there's nothing wrong. You got to go back to the original meaning. You got to go back to the practice of the time. I certainly rely on colonial practice, post-ratification practice, but I don't necessarily view that as tradition. I view that as history. So when you start getting back into that, it becomes a slippery slope as to what you're actually doing, or slippery to sort of name it. And so tradition, I think, might be in some ways, if you're not disciplined about it, a way to become a living constitutionalist by another name, which is to look at how things have evolved in society and the practices that have evolved, even if they might be unconstitutional.
Professor Gerges, if you would care to comment on this, that would be great. And then what is your thought? It seems that in Rahimi, Justice Thomas, in his dissent, was arguing tradition from both a criminal point of view and a civil point of view, the surety laws within the civil point of view. And that seemed to be kind of a difficult thing to get to in terms of tradition, really. But I don't know if you even have a position on that.
Sure. So I think that's a special case of the general problem that Jeff was describing as the levels of generality issue. And there's an interesting division that shows up if you read the footnotes in Rahimi, where Justice Barrett, in her footnote, it's one footnote, so it's just a star, not a number. She says, by the way, so she, above the line, she says, look, what really matters is the practices or traditions that I look to are the early ones, because I want them to either be evidence of how people use the words at the time, and that's original meaning, or evidence of the practices that got incorporated effectively by reference by the Second Amendment. And that's the original contours of the pre-existing right. But then in a footnote, she says, and by the way, those early practices, and she's talking about regulations of various kinds, whether they're criminal or civil, don't themselves have the status of constitutional law. They're really just evidence of how people expected the principles that embody the Second Amendment to be applied. And what I'm after is the principles. And I think from that perspective, which Justice Thomas doesn't reject or affirm, it wouldn't really matter whether it was civil or criminal. I think you're looking in general at what kinds of burdens people thought were acceptable on access to keeping and bearing arms for self-defense and which ones were deemed unacceptable. And then you're using that to kind of triangulate to a set of principles that might or might not have exactly matched any one regulation at the time, that you might in principle have better evidence of in a treatise than you would in a debate about a regulation that a state was considering adopting at a time when the Second Amendment wasn't incorporated against it, and so on. But I think that in a way makes things tougher because of what I just said. There's not going to be, you can't guarantee that you're always going to have some very discrete regulation that you can read the principle directly off of, and that raises the risk of going back to the kind of thing the Supreme Court was specifically trying to reject in Bruen, which is reading the levels of generality so high that you end up saying, well, you know what? For example, I mean, some of the principles that have been proposed are there's a principle that says you can disarm dangerous people, and there's a principle that says you can exclude guns from sensitive sites, and then there's a principle that says you can exclude dangerous or unusual weapons, and there's a principle that says you can exclude dangerous manners of exercising these rights. So that's people, places, and things. It's all the nouns. So it's and it's dangerousness. So if the lesson you take from that is that if the person or the place or the thing or the manner is dangerous, you can regulate it, then you're effectively back to the balancing tests that the Supreme Court was trying to reject in Bruen, where a court just asks, is the thing this regulation is fighting sufficiently dangerous that the regulation is okay? And I think that's the tension the court finds itself in. Rahimi was read by a lot of people to reflect 1 inch or 1 foot or maybe a yard back in that direction, where the court said, no, Justice Thomas and the Fifth Circuit were looking for very close cousins of the regulation under review in the past to say that this regulation's okay. Really what you should do is zoom out and look at the principles. And the question is whether you can stop the zooming out so that you don't just go back to the balancing that Bruen wanted to avoid.
So I'm going to go to Jeff in a second, but as a follow-up to you, Professor Gerges, so the sensitive sites angle, it's pretty interesting. Historically, if you look at the sensitive sites, it's typically courthouses, election lines. One of our judges in Florida has written a very well-written opinion that said that tradition did not prohibit possession of guns in post offices. Now, but there's a conflict between how the 11th is going to look at that versus how the Supreme Court might look at it in Bruen. So the 11th, I don't know, maybe they'll hear it on banc and change. I don't know what they'll do, but it's kind of following up on what I asked Judge Strauss. What do we do as district judges in that kind of a situation? Well, what do you suggest, at least? There's probably not an easy answer.
Right. I'm the least practical person in the room, so I can't advise people who have a real day job. But I would say if you're a judge, you're trying to figure out what to do. I mean, the court has told you some guardrails. So on the one hand, it has said you don't have to find, as Justice Thomas put it in Bruen, a dead ringer for the historical regulation. So for example, if there's a law saying you can't carry guns in public schools, but there's no founding era regulation because public schools weren't as much of a thing at the founding, then that can't by itself cut against the state regulation. On the other hand, you can't ratchet the level of generality up so high that you end up disarming a majority of people like the Bruen regulation did. And so, for example, some localities and cities have said, look, there were these going armed laws that said you can't go waving a gun around in a really crowded place. Well, Manhattan's really crowded, so you can't have a gun in Manhattan, or something like that. And the court has said, no, you can't go that broad. So that creates some boundaries. And then the question is just, where do you draw the line in between? And I don't think there's guidance in the Supreme Court's precedent or in text or history for exactly how finely or coarsely to draw those analogies.
Right, Jeff, you're my cleanup guy. So I need you to comment on all these different things you heard and practice. How does that?
Yeah, or let me tee up 2 others that I think are really interesting and very live issues. Number one, this same Isidore case just got granted. How do we do, is there like an anti-tradition doctrine? So starting in the 1870s, 38 states adopted Blaine amendments to their state constitutions that ban the use of public funds to support sectarian schools. There's no question, I think has been shown, Justice Alito wrote in Espinoza, and there's been a lot of writing. These were very anti-Catholic laws that were motivated by animus against a certain group. But we had 38 states that passed them, and they've obviously come under attack and challenge. But as we get to a case like Saint Isidore of I'm not sure exactly how the QP would be phrased, but does it violate the Establishment Clause for a state to financially support a religious charter school? Is that fair? And so, what do we do with this Blaine Amendment history and tradition? And again, is there a role for sort of anti-tradition? The second one I'll throw out, which I'm sure we'll solve in the next 17 minutes, is what to do about substantive due process, where you have a doctrine that everyone agrees is sort of made up, but ironically says you're supposed to look to history and tradition. And that obviously has the overlay of, privileges or immunities and whether anything is coming back through there. But just on a very concrete level, think about a lot of the cases about, it's not teed up in the Skermetti case, but a lot of the cases about sex transitions on kids have a parental rights substantive due process claim. And there again, do you frame the tradition as the parents have a right to control the health and upbringing of their children? Or do you frame it as, do the parents have a constitutional right to give cross-sex medical interventions to children? And so, again, just to agree with the previous point of where you're zooming the lens can often essentially answer the question.
Great. All right, Professor Lawson, back over to you then.
Yeah, no, I mean, I think that that illustrates the problem that academics have trying to give guidance to judges. We're kind of asking different questions under different kinds of constraints. I think do I have the answer to the correct level of generality of these things? Well, no, I think I can describe how to go about it. The question is what was, quote, the right to keep and bear arms? What are the things and relations in the world that phrase maps onto? Are you going to be able to answer that question by looking at the practices and customs of 18th century states? Well, probably not. You're going to need to look at a whole lot more things than that to figure out what we, the people, this hypothetical legal entity, meant by the right to keep and bear arms. Same thing with the jury. What's a jury? A jury is a thing and set of things and relations in the world, and the word in the Constitution reaches out and grabs onto what those things and relations are. Well, what are the characteristics of those things and relations? I don't see how that can possibly be a strictly historical question. History would be one little strand of that. Tradition, if you believe in that sort of thing, might be one strand. I wouldn't look to it. But the bottom line is, if all of these were easy cases, we could replace all of the judges with Chat GPT. And I don't think that's the case. I think they're going to be very hard cases. And it's not a knock on originalism that there are hard cases. Every single methodology you come up with is going to have hard cases, unless it's, rule in favor of whichever way the coin flips. Even if it's rule in favor of whichever party you like the best, there are going to be cases where it's really hard to figure out which party you like the best. So all that's going to change is which cases turn out to be the hard ones, and how many of them are hard and how many of them are easy. So I would say take it as a good thing that we're pointing out all of these hard cases, because we're not going to be abolishing the court system anytime soon. Sorry, that's all I got, folks.
So in the jury unanimity question, it seems that it's fairly concrete, where you have the federal system and the systems of 50 states. But where do you go if you're looking at prior regulation? How far back do you go? Is it just what state legislators have done? Do you look at what cities have done? What would you do? Jeff, what would you do in that kind of thing in terms of determining what's the barometer for history and tradition? How low would you go?
Yeah, well, and that also overlays, and again, I'm a lawyer representing a client, so for those who ascribe to such things, we also pointed out the international trend has been towards non-unanimity. And in fact, England, which developed the jury system, allows non-unanimous juries. So again, as an advocate, we have to tee up something that could appeal to anyone. But no, I do think especially, in ours was obviously, the Sixth Amendment as incorporated against the states by the 14th Amendment. And so obviously state practice is going to be the most relevant thing. But again, I'd be not doing my job if I didn't give Breyer and Sotomayor and Kagan something to see about what's happening internationally, which I thought supported us pretty convincingly.
Sure.
Let me just throw one more thing out there. Yeah, there are a lot of easy cases, by the way. It's not every case is a hard case. We tend to focus on the hard cases. There's a whole bunch of cases that are very easy. Lots of stuff that originalism solves very, very readily. But as my old mentor who passed away just about a month ago, George Priest wrote about decades ago, the cases that are going to be litigated, they're going to tend to be the harder ones rather than the easy ones. So I would be too hesitant in drawing conclusions about indeterminacy and, well, this isn't going to work. Make a list in your head of all the cases that are really, really, really easy under any plausible version of original meaning, regardless of whether you think about text, history, tradition, what order you put them in, how you rank them. There's lots and lots of cases where everything converges on exactly the same answer, no matter how you go about it. Just throw that out.
Judge Strauss, before we go to questions, what do you?
So on the zoom in, zoom out question, which folks have talked about, I actually think Justice Thomas provided us a clue of how to do it in Bruen. The word analog, analogies, came up repeatedly in that opinion. What we are doing when we're doing this sort of historical research, at least in my humble view, is what lawyers do every day. We ask the question, is this case close enough to the case in front of us for the case to control? And I think with historical analysis, you're asking a very similar question. You're trying to figure out whether the analogies that you've found, whether it be colonial, whether it be city or state, or whether it be post-ratification, are those practices close enough to provide us guidance for this particular case? And ultimately, it becomes a judgment call, but it's not all that different than what we do in qualified immunity, where we ask, is the case clearly, prior case clearly established? You're asking different questions, but you're doing the same basic analysis. The difference is the input is historical materials versus prior cases, or not exclusively prior cases, because cases certainly can be relevant. And so it's a challenge for the advocate to make that case to the judges, but it's also a challenge for the judges to sort of zoom out at the right level of generality. But I do think, to give a plug to my old boss, Justice Thomas, I think the words he used were very carefully written, and they were to tell everybody, this isn't all that much different than what lawyers and judges do on a daily basis.
Prior cases are historical materials.
Right.
So he's even more right than you said. No, it's true. They are.
They are.
Historical materials. It's exactly what they are.
Folks, we're 10 minutes away from your happy hour. I know you want to get out there, but I want to make sure that we've left some time for questions like we always do.
Good afternoon. This is primarily for the judges, but when you're doing this analysis, how constraining is party presentment? So if you are not given good historical arguments, how do you go about that process?
So that's a great question. And we get, with all due respect to the attorneys who've appeared before me who try very, very hard, they are new to this for the most part, especially prosecutors and defense attorneys. They're doing other types of legal analysis. And so it's not great, the briefing we've gotten. But they've at least in most cases cited some things that are relevant that allow us to then take as a jumping off point the things they've cited. So I don't, in those cases, I'm not gonna say, presume that what they say is the end all be all of what the historical analysis says. I'm gonna do my own independent research too. And sometimes they just miss analogs. In my 922 G3 case, I believe the parties talked about going armed laws, which was one of the analogies, but didn't talk at all about the mentally ill. And so sometimes you have to sort of do the analogy and figure it out yourself. And so we're still working that out, but it is a really, really tough thing when you're asking people to do something that they haven't done before necessarily.
So Judge Strauss and I have gone to a seminar together before where it's interesting because some of the appellate state court judges from other states will actually ask for supplemental briefing. I don't think that's a great idea in terms of that. So I don't do that. But from a district court judge perspective, I get a 922G case probably once a week. And there are a lot of motions that are filed on those. And I will say, at least in the Southern District of Florida, the Federal Public Defender's Office is really on top of this. They file just some excellent motions and arguments. I think my guess is they're trying to tee it up for an en banc review from the 11th to see if there'll be a change. I think you were next, and then I'll go over to you.
Hi, Eric Palmer. Wanted to throw out maybe a quasi-heretical possibility on this and kind of gauge the panel's reaction. When the possibility I have in mind is maybe Justice Kavanaugh is right to affirm a trinity of text, history, and tradition against a simple dualism of text and history, but we haven't appropriately theorized what could meaningfully be meant by tradition. And I think one option would be to think that tradition is the Western legal tradition of juristic thought, beginning with natural law, unfolded through the course of Roman law and the English legal tradition, and that our Constitution presupposes that backdrop and must be interpreted in the light of it. And I would think that this way of viewing tradition would not boil down to a Justice Kennedy-style head count where you look at when states adopted various policies and how many of them are on one side or the other, but it also would not leave us with a conception of analogy that doesn't sort of latch on to a real metric of comparison. And I think that's maybe something that's found sort of kind of analytically difficult about Bruen is that we're told, look for an analogy, but it's hard to know what an analogy really can do if you haven't isolated a principle that's the basis of that comparison.
So, Professor Gerges, to the extent you heard a question, if you could answer that.
Yeah, I think that something.
There's no question, it's just a rant, sorry.
Yeah. React, discuss. So I think there's one article that develops something that sounds close to this, which is a piece by Will Bode and Robert Leiter called something like the general laws of the Second Amendment. And they think that the Second Amendment is best understood, and actually Bruen is best, if you squint, is best read to suggest that the Second Amendment, yes, it incorporated a pre-existing right, but that pre-existing right was not some list of concrete principles. It was a general law right, which means a right that is common to all at least all Anglo-American jurisdictions, not sourced from one of them, and doesn't come down from a sovereign like a legislature or a constitutional ratifier, but bubbles up from some mix of custom and reason, where reason is understood in something like the kind of natural right, natural law way that some at the founding thought about these things, and where custom is a guide, but admittedly runs out, and when it does run out, reason can play its own more robust and assertive role. And on that conception, I think there's something very similar to what you're describing, and that's one on which originalism and traditionalism would merge because the original meaning picks out a general law conception.
Thank you. I'm probably 2 or 3 years ahead of my time, but that's only because Justice Barrett was in her opinion. She comments that imposing a test that demands overly specific analogs has serious problems, and identifies one of those problems as the legislature not maximally exercising their power to regulate. and adopting a use it or lose it view of legislation. I want to apply that to something that we saw last week in an executive order, and that's the first clause of the 14th Amendment. When it was enacted, the legislature did not fully exercise their right to regulate immigration. And the first clause of the 14th Amendment says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. And the language in subject to the jurisdiction thereof was seized on by President Trump in his executive order. And talking about analogs here, at the time, that was understood to mean that persons who were diplomats and subject to diplomatic immunity were not subject to the laws of the United States and therefore were not citizens when born here. Can we take that as an analog, as President Trump has sought to do, and apply that to illegal immigration where it was not fully regulated by the legislature at the time that the amendment was enacted?
Professor Lawson, you have an opinion on this? I'm thinking that the judges should stay out of this one.
Yeah. Not something that's directly within my wheelhouse. I'll just throw these things out. To me, the question is, what are the things and relations in the world that phrase subject to the jurisdiction of the United States latches onto? I don't know that for exactly the reasons you're suggesting, I don't know that the practices of the time are going to be terribly helpful. I suspect that something like general law is going to be more helpful for figuring that out, but that's not something that I have ever spent any time or energy looking into. The only thing I will say to shock the audience is one of the easy questions under originalism is that Congress has no power over immigration whatsoever. Congress has power over naturalization, but immigration is entirely, as a matter of original meaning, up to the states. Maybe the president actually can get involved in times of war, but read the Constitution. There is no congressional enumerated power over immigration, but that's a different question.
Thank you.
But you could be our last question, and then we'll get going.
All right, thank you, Judge. Professor Lawson said that academics don't have an answer to this question of what the right level of generality is. That's right. And Judge Strauss suggested that Justice Thomas has already pointed the way with the use of the term analog. But it seems like the justices in Rahimi disagreed on which analogs were analogs, and if they were, how they applied. So it seems like there's some theoretical work to be done here. The thing that concerns me is whether we have to answer this question anew for each right or each clause that we interpret, or whether there may be, right, even if we don't have an answer to the question now of what the right level of generality is, can we have an answer to what the answer will look like? Do we think that there is one correct originalist approach to levels of generality that will apply trans-substantively? Or is this something we have to work out right by right, clause by clause? And if it's the latter, which I'm afraid is what everyone is sort of gesturing towards, is there a way to justify this that doesn't make it look like we are ad hoc trying to get the answers we like? Anybody?
You want to take that one?
Sure. He's my student, so he's trying to get a good grade. It's all blind grading, though. So I think that I think it's impossible in principle to specify ahead of. I mean, imagine what an answer would look like. Forget about which answer is the right answer. Imagine what it would look like to give the answer. The answer is not a number. It's like, well, you should turn the dial to 4 on the levels of generality scale. And if it's not a number, then it's not going to be specifiable in advance, except in these very broad strokes ways, like you should not define it so high that almost nobody gets to keep or bear a gun, and you should not define it so low that the government can't do anything it didn't already do in 1791. And between those two things, it's not just that. I don't think there's a single answer across all of them. I don't think it would be possible to specify it in advance if there was one, and I think you should just there's a kind of delegation to the judges to pick an answer for the case at hand.
Now, I'll just throw in, I do think it's clause by clause, but I don't think it's quite as catastrophic as the question suggests, because different not clause by, I always say phrase by phrase, word by word. Different parts of the Constitution are going to present different generality problems. There are going to be some clauses that present quite serious generality problems. We're talking about some of them. If we were talking about different clauses, we were talking about the Senate clause, we wouldn't be worrying about the level of generality at which you define the Senate. So I do think you need to look at each particular thing that you are interpreting, and sometimes it's going to present you with these generality problems, and sometimes it won't. So I'm guessing that when Steve Calabresi and I get around to writing our multi-volume epic, which I'm sure will be available on Amazon for quick delivery, I kind of suspect we're going to end up having to do it on a piecemeal basis. I don't think there are certain very broad general principles that define originalism, but applying them requires reading what you're trying to interpret. You gotta go where we the people told you to go.
Folks, it's a real honor to be on this panel with these four gentlemen here.